lot of these matters end up getting resolved through negotiation of some kind of license. So while you may proactively enforce and protect the territory of your marks or your copyright interest, that doesn't mean you're going to sue every single one of these infringers.
Yeah, absolutely. I would say it's few and far between where you have a particular situation where you have to go right into litigation. There are times that one has to do that. It's just, I've got to protect the business. This is what's required. I'm going to file a lawsuit. Maybe you have a cease and desist letter first. Maybe you don't. Most of the time, one hopes that by reaching out and then negotiating, you can reach an amicable resolution, whether that includes some kind of license and compensation for that, or it's putting in place certain parameters. You can use this particular term, but please always use it in connection with this logo, or you can only use it in these particular countries. I mean, there are all sorts of parameters one can put in place to avoid consumer confusion and allay the infringement concerns.
And the whole point of trademark is to avoid substantial chance of confusion between goods or services from one mark to another.
Right. So the mantra in trademark infringement is consumer confusion. You are looking for whether or not there's a likelihood of consumer confusion, because trademark, one of the reasons for trademarks, not the only reason, but one of the most important reasons for trademark law is to give consumers a way to differentiate among goods and services and not be confused. So it goes back to, what is a trademark? It allows one to identify a good or service with one exclusive source, so that when they see that brand or that trademark, they understand, aha, I've bought that good or service before, and I trust the source. When I see that, I know that's what I'm getting. You don't want to confuse the consumer. That's, one of the biggest protections. It's, providing value to the trademark owner, but it's also providing significant value to the consumer. And for copyright, the question is substantial similarity. So it's, copying. Do you have access to the prior work? It can happen that very similar works can be created with neither party having access to the other. I mean, that just happens. That's part of the creative process. And we are all sort of building on things that have gone before. So it can be that you've got two works that are substantially similar, but neither party had access to the other. And so that's not copyright infringement. You've got to have the copying and the substantial similarity piece.
And I take it that the same sort of decision tree that in-house counsel's making in terms of defining which are core marks, which are the private label marks that most need protection, where those are going to be filed, that the same type of decision tree is going to be followed with respect to enforcement and what the nature of that enforcement looks like.
Yes, absolutely. Well, like I said, I mean, particularly for trademark, but for copyright too, it depends on the nature of the client's business. If you're primarily a business that is, brand facing, well, then it's probably going to be a trademark strategy that I'm, working on the most with you. But one of those strategies is going to be the enforcement program. What infringers to go after, when, in what way, what tone. If the client is primarily content driven, then you're going to engage in the same kind of, strategic considerations from the copyright point of view.